Justice Fisher, how does your background inform you as a judge in your position? And what I mean by that is how you operate and your judicial philosophy.
Well, I was a trial attorney representing big and mostly small companies for almost 3 decades. And one thing I learned is businesses, including farms, can adapt as long as they know what the law is. They might not like a law, but they'll figure out a way around it. And that what I saw as a younger lawyer was the Gang of Four at the Ohio Supreme Court in the 90s would go like this. One case would go 180 degrees the next. I had one client call me up, want me to talk to him, and 3 weeks later, when I finally got to meet with them, the court had gone 180 degrees the opposite way. They said, well, what should we do? I said, well, first of all, you should have called me before. You should have hired me earlier, but I think looking at the law, whether it's the Constitution, a statute, or a contract, and enforcing the contract, the statute, or the Constitution as written, not making me legislator from the bench, makes for a better world, both individually and for every business here, because you know what your rights and obligations are. And if people just, some people believe in a so-called living constitution. Well, if that's what it is, it's whatever the judge feels like who's sitting in that chair, and that's when you get this. And that's when you lose businesses, and that's when you lose young people moving out of the state. And I believe the opposite. I believe in the text. And I learned that early on as a lawyer because I saw businesses having a very difficult time, especially farms and small businesses, when the court would go like this.
Justice DeWine?
You know, my judicial philosophy is probably not that different than Justice Fisher's. I believe the role of a judge is to apply the law as it's written. It's not to go out and make law. It's not to say what do I think the law should be, but it's to take whatever's in front of us, whether it's a statute, whether it's a contract, or whether it's the Constitution, and apply the plain meaning of that document, apply the meaning as it was originally understood by the people who drafted it. And I think if we do that, what we do is we create certainty. So people know what the rules are so that they can go out, they can invest, they can make decisions, they can do things that make this a better, more prosperous state. And if you don't know what the rules are, then you don't do those things. I mean, one of the reasons that's so hard to do business in third world countries are because they don't have legal systems that have a clear rule of law so people know what the rules are, that protect property rights, very important, obviously. So people don't want to invest in new business. So I think a big part of my philosophy is centered on that idea that we ought to apply predictability and certainty. How's my background? How's that come from my background? I think a number of ways. Growing up, I grew up in a small town. Grew up in Cedarville, Ohio, and I think those were kind of the values that people had where I grew up. But also, I thought a lot about it. I remember, for me, actually, it's kind of a maybe a little nerdy experience. But when I was in high school, I picked up the book. Some of you may remember President Reagan's nomination of Robert Bork, who didn't make it on the Supreme Court. It's kind of the first time that there had been a group that really kind of went after someone, but because he was too conservative. But I read Robert Bork's book after The Tempting of America, and he outlined kind of why he thought the original understanding of the Constitution made sense for judges, that was the only way that we had judges who would actually apply the law and not out there making the law. And that resonated to me, and it's kind of really informed my philosophy, like been the roots of my philosophy to this day.
Leah, it seems like every day there's a new topic of conversation when it comes to litigation and the courts across Ohio, whether it be Supreme Court or on down the line. How do we at Farm Bureau keep an eye on what's going on?
So we spend a lot of time at Farm Bureau monitoring cases. We probably have a list of 30 different cases across the country and the state that we follow all the time. And we are trying to keep track of what are those rulings, what do they mean for people. And I love what you're both saying because, I became a lawyer because I wanted to be able to talk to my grandma about what the law was. I wanted my grandma who, had to drop out of high school in the Depression and got her GED. I wanted her to understand it. And that's what I hope I can do for all of our members and what all of us in our team hope to do. But then we also at Farm Bureau, we get involved in litigation. We often get involved as what's called an amicus curiae. We lawyers love our Latin words, but that means a friend of the court. And we try to take that opportunity to give the court a broader understanding of how laws and disputes and contracts are affecting us in our industry. And how we think that case should be decided and why we think it should be decided that way. And we've had a very good run of the cases we've gotten involved with, and I think we've been able to positively affect how those cases have come out.
The Supreme Court here in Ohio has been in the news headlines for the past couple of weeks, and so I say this and ask this question with a little tongue-in-cheek because I know there hasn't been a normal day for you guys for some time, but what would a normal day look like for you guys on the court?
I'll let you go first on this.
There's really not a normal day. What I tell people is, your image of, you think of me as a judge, Justice Fisher, you probably image as someone sitting behind a bench wearing a robe. And we do that, but actually that's the minority. That's a pretty small minority of our time. For us, most of our days are spent reading and writing. So most days I'm either reading briefs, getting ready for the next argument, or reading. Sometimes we hear a lot of cases where we vote on, we don't actually hear arguments. So sometimes I'll be reading cases, casting votes, like for example, what cases should we actually hear? So every 2 weeks, we'll vote on about 50 cases, whether or not to bring them into the court or not. So a lot of my time will be spending reading those things. And then a good portion of the rest of my time is writing opinions. I spend a lot of time writing because we don't. What we do, it's not like Law and Order. We don't just come out and just announce what we decided. We decide by written opinions, and the reason we do that is because we want people to understand not just what we decided, but why we decided it. And that allows lower courts to apply what we decided to different facts. It also helps the parties, lawyers, understand what the law is in Ohio. So I spend a lot of time trying to write as clearly as I can. When I write an opinion, I try to, one thing I always think about is exactly what Leah said is, how would you say this to your grandmother? I always think that's, when you're writing something as a lawyer, I don't want to write like a lawyer. I want to write like my grandmother or Leah's grandmother, your grandmother can pick it up and read it. So I work really hard to try to write in plain English so people could understand it. And I try to think about, okay, if the losing party picks up this opinion, what would they think? They're not going to like the result, but at least I want them to understand that this decision wasn't based on the whims of judges. It wasn't based on who we liked or disliked, but it was based on precedent and the rule of law. So I try to write opinions that accomplish that. So I guess the short answer to your question is every day is different, but most of them are spent somewhere. Either Columbus, I have an office at UC Law School. Sometimes I spend time, I'm on the road, at Starbucks, but most of it's spent reading and writing. And when it's not, we're on the bench about 5 or 6 days a month, and the rest of the time.
I'm intrigued, Justice Fisher, about how you might be a little different in the way and the process you go about writing opinion. Is it similar to Justice DeWine?
It is. First thing I always tell my law clerks, kind of what Justice DeWine's talking about, I want to write the opinion not for the losing lawyer, but for the losing party. So that not only do they understand it, they will feel that their argument was at least heard, and that with reason or precedent or statute that they lost, but never in a demeaning way, always respectful of especially the losing party. My day would be pretty much like Justice DeWine's. let me though maybe look at a day when we do have court. How's that? If the day we have court, come in a little earlier, say about 8, talk to my staff, go over last issues for oral argument. Oral argument generally takes from 9 to 11, 4 cases, half an hour each, so say 11:30 with breaks and all that. I'm not Clarence Thomas. I do ask questions, but not many, because I practiced for so long. I want the justices to hear what the lawyer has to say. But a question the other day, one of the lawyers cited a bunch of cases based upon a federal rule, which is parallel to the Ohio rule, but it uses the word may. Now, the Ohio rule uses the word shall. And I just looked at him and I said, doesn't shall mean must? And he kind of, yeah. But words, I look at all the words, and each word matters. And each word that's not there matters, too. Because sometimes you got statutes or provisions where some words are used in one provision and not the other, and so you got to deal with that. But so after oral argument, we go upstairs, 9th floor, generally, unless it's Zoom time and COVID and all that, but on a normal day, sit around this egg-shaped table, and we vote. And it's a very elaborate discussion. The chief always speaks first, then the most senior justice, which Justice Kennedy was here earlier, right? Then me, then Justice DeWine, then Justice Donnelly, then Justice Stewart, then Justice Bruner. You never interrupt them. I wish everybody could see it, because it would really help political discourse in this country. Because they're smart people in that room, and they articulate very well their viewpoints. But after that, this is my favorite part. It's wide open discussion. And you go back and forth, and for those that are lawyers, it's like law school. 2 a.m, you're deciding the rules of the world, right? But it's a very good discussion because people are smart and they got smart law clerks. Then after that, we vote on the case. But the vote's in the opposite order. The most junior votes first, and you go up in seniority till Justice Kennedy, and then the chief votes last. And I think that's a tradition so that the chief can break a tie. Then the U.S. Supreme Court gives the authorship to the majority, either the Chief Justice if he or she's in the majority, or the most senior justice in the majority, and they determine who writes. So there's all these articles about who's friends with Chief Justice Roberts, who's friends with Clarence Thomas, because he's the most senior conservative, and who's friends with Justice Breyer, he's the most senior liberal, and does it matter, is it unfair the way they distribute the cases? Ours is at random. There's a black bottle, very narrow at the top, wider at the bottom. If anybody ever plays Kelly Pool, looks like a Kelly Pool bottle. And in there, they're up to 7 numbers, 1 through 7. And we get a number. I'm number 5. It's got nothing to do with your seniority. It's just what number you get when you're there. And everybody who's in the majority, so let's say 1 through 5 are in the majority, 6 and 7 are in the dissent. 1 through 5 marbles would be put in there. Justice Kennedy is the senior non-chief justice, shakes it up, hands it out. Whatever number comes out, random. Just totally random. Now, we do make it so that everybody gets an equal number. So if you're in the majority in this case, and you're in the majority in the next case, your marble won't go in so that somebody else gets. But and then I tell my staff what I want written. They do a first draft. They throw in some citations. I check it, go back and forth. It's an iterative process. Then it's just sent down to the reporter's office. They edit it. They send it back. We send it back to them. They send it back to us. Finally, we distribute it to everybody. And then you start getting the dissents. So the dissent might come up, and then you have to rewrite your majority to answer the dissent. And that's why sometimes it seems like for some of you it may seem like a long time. But it's a very, very definitive way to make sure it's high quality and that the answer is right. I really push for efficiency, and we really have made the court more efficient since we've been there. but getting it right's more important. And thus, this goes out. And then finally, after everybody does it, we vote again at another session and prove it's probably 5-2 with a dissent or two, and it gets published about a week or two later. So that's, and then there's always a motion to reconsider, right? They don't go very far usually, but sometimes they do. So that's the whole process.
That bottle with the numbers, the same way we figure out who's going to do dishes at home. So the exact same process.
You know what, though? It's got to be from a group of marbles that had at least 10 numbers, because the number 6 is spelled S-I-X. It's not, 6.
Right. Because you don't know if it's a 9.
But with only 7 people, you would know it would be the 6, right? But it must be from a different list. So.
As you know, this room is filled with farmers, those that have interest in agriculture and agribusiness. So how do you see the court's role in agriculture as a whole? And Justice DeWine, we'll start with you.
Yeah, I mean, I don't think our role is that different in agriculture than anything else, but I think that, the things that people in the agriculture industry should care about from a court are, one, protecting property rights. I'm someone who believes strongly that our Constitution guarantees property rights and its judiciary's role in rights. Second, is, as I mentioned before, I think you want certainty in the law. You don't want judges to make the law. You've got legislatures that make the law. You can go lobby them. You can talk to them. Judges shouldn't be making the law. Judges should be applying the law as it's written. And on the same token, I write a lot about, and I've written some articles in like the Yale Law Journal, but about something called administrative deference, which is it's kind of complicated legal term, but what it's really about is who's going to make decisions, whether bureaucrats are going to make decisions or whether the people who are elected and judges are going to make the decisions that affect your life. And my judicial philosophy is that, we shouldn't turn that, the court shouldn't allow that authority, these regulatory authority, to be turned over to unelected bureaucrats, essentially.
Justice Fischer.
Everything ditto. I want to add one thing. I'm also licensed in Texas. So I have a very keen interest in oil and gas, and that affects your all property rights, especially on the east side of the state. And I think it's important to realize that at the turn of the century, the 1890s to 1900, how many cases there are out there. Ohio was one of the leading oil and gas decision cases, and then there's nothing for a long time. And then the Dormant Minerals Act, et cetera, came up. But that also riparian rights, I had to learn in Texas because water is a big deal. Now, we don't fight over water as much in Ohio, but the day could come when it could be. So these cases about oil, gas, and water are very important. It's not just the dirt. It's not just the soil. But property rights are bigger than that. And we both have very similar, that people need to know what their rights and obligations are and to be clear about it. And thus, a lot of people bring us cases and we have to apply the law to the facts as given. And sometimes you're not going to like the result. But to get that certainty, get that specificity for long-term interest of the state is very, very important.
I don't know a lot about law. They don't teach that in communication school very often, so I don't have much of a background. That's why we're so lucky, all of us, to have Leah Curtis on staff. And one of the first terms that I didn't know what I was talking about and went to her was amicus briefs, and we do that quite a bit at Farm Bureau. And Leah, I want to just kind of have you set the stage and tell us what that is and how we utilize that with the courts on all levels.
Sure. So as I mentioned before, amicus curiae is friend of the court. Again, we love our Latin. And it is a way for a person who's not a party to the case to provide another perspective or a different viewpoint on what's happening. So the parties in the case, they're going to argue about the legal arguments. That's where they're going to focus on. And an amicus may provide legal arguments as well, but they're also going to provide more kind of practical, environmental, things that are going on outside of just the law, so that the justices have kind of a broader sense of how this impacts different people. And that's what we do. We try to, in our briefs, talk about how does this affect agriculture specifically. And sometimes, we've all seen it happen where a law might sound good, though, when you hear about it, but then when you go to actually do whatever it says, it doesn't work out, right? Like I can't get the form that I need or whatever. So we try to make sure that those practical aspects are also a part of it. A really good example is CAUV, right? We all know about CAUV. There was a case a few years ago at the court, and we wanted to make sure that the court knew all that we knew about CAUV. Obviously, we're one of the experts on that program, our organization is. And so we probably our longest brief we've ever submitted, but we went through from the start of the tax department all the way to the county auditor and how it works to make sure that that full process was explained before they got to the legal arguments as well.
How do briefs impact your decision?
How to brief generally, or amicus briefs, or
Yeah.
both? Well, so that's a great, I think, place to start, briefs and amicus briefs. So when we have a case, we're going to get a brief from each side, and each party's going to say why they think they should win, right? And that's what we do. We decide disputes between people. But when we make a decision, it applies not just to the two parties in front of us, but every court in Ohio is going to have to apply that decision to different people. So the great thing about amicus briefs, like the Farm Bureau Files one, is they can point out something that says, this is how it's going to affect every farmer in the state, or every farmer, whoever it's going to affect. And so the parties don't really have an incentive to talk about how it affects other people. They're just going to talk about why they think they should win. So in some cases, it can be really helpful to have an amicus brief who points out, says, okay, it may, if you rule this way, court, it's going to have this impact in this case, but it's also going to mean that for every property owner in the state of Ohio, X, Y, Z is going to happen, right? So that can be really helpful information. And I think I actually wrote the opinion in that CAUV case, and I remember, I knew something about it just from my family's land, but I didn't understand how the process operated from beginning to end. So having that kind of overview, that kind of background from the Farm Bureau is very helpful when I wrote that opinion.
I want to add one thing. Amicus briefs are very helpful because the standard about whether we take a case in, the U.S. Supreme Court doesn't take every case. They have tens of thousands of applicants, and they take 70 cases. We have about 1,600 applications a year for a case, and we take in about 120 to 150. Okay? But the amicus brief would also be helpful sometimes, not just on the merits of the case, but whether we should take the case in. Because the standard is the issue of constitutional dimension or of great public or statewide interest, general interest. And often, the parties, when they're writing their motions for jurisdiction, is what it's called, again, as Justice DeWine would say, they don't care about everybody in the state. They just care about winning or losing. Parties they really don't care how they win or lose, to be honest with you. They just want to win or lose. But the amicus brief, especially on the motion for jurisdiction, is helpful because of that standard. Is it of great general or statewide general interest, public interest, or constitutional dimension? And how a ruling by us would affect the whole state, not just these parties. So I think sometimes, you guys do it sometimes, yep. I think associations often, not you guys so much, because you guys submit a lot of them, but there's some associations that only submit amicus briefs on the merits. But if we didn't take the case in to start out with, you don't ever get the merit brief. You never get to it. So I think sometimes merit briefs on the motion for jurisdiction is almost as important, if not more so, than on the merits sometimes. Mm-hmm.
Leah, you mentioned CAUV. What are some other cases that Ohio Farm Bureau has been involved in that resulted in good outcomes for our members?
So I'll highlight two. We've had a lot over the years, but a few years ago we had a case called Metamora Grain Elevator v. Fulton County. And so that was dealing with whether a grain bin was going to be taxed for property tax purposes. And silos generally are not, and that was clear in the law. But we had this kind of gray area where grain bins are, kind of the same as silos, right? They're the same function. They're not permanent. And we had a grain elevator that challenged that. They were able to win at the Board of Tax Appeals, but then it went on to the Ohio Supreme Court. And we were able to help with, when we do this, we talk with the attorneys throughout the whole process. And we kind of say, like, here's what we think could be helpful. What do you think could be helpful? We try to work together. And we were able to say to the attorney, he's not from a farm background, and we were able to say, like, well, that there's a sales tax exemption for these grain bins, because we pay sales tax generally on personal property. That's a good argument maybe that it, shouldn't be real property. And he was kind of like, oh, well, can you talk about that? Could you cover that for me, please? So we wrote a brief about, the importance of having a clear standard, making sure people understood at the county level, and all that kind of background information. Grain bins are sold on the open market. They get taxed if you don't have a farm sales tax exemption. And eventually the outcome of that case was that grain bins are not taxed anymore on your tax bill. So, for a normal grain bin, that might be $10 a year. A bigger one might be more. But that's a savings you're going to see every single year on your tax bill going forward. And then another case we got involved with, which was actually the U.S. Supreme Court, had to do with property rights. And I love what we're talking about here, because we joke sometimes in my house that eminent domain and private property rights are what keep me up at night. I'll sit up at night and think of something that I need to write down the next morning. And we got involved in the U.S. Supreme Court over the ability to take a eminent domain case to federal court. And it was really exciting. We got to go to the argument as well. It was the first time we as an organization had filed in a U.S. Supreme Court case. It ended up going out the way we wanted, that we can now take those cases to federal court. And even more exciting, if you're a nerd like me, is that Chief Justice John Roberts wrote the opinion, and he cited Ohio as a specific example, which he wouldn't know if he didn't read our brief. So I'm just going to take that to mean he knew our brief. And he cited a specific case that is an Ohio case that he would not really know probably other than from our brief. So it was a very exciting experience, and we're really glad to see that decision.
We can officially say you geeked out over that.
There was a little bit of geeking out, I'll admit.
You mentioned the U.S. Supreme Court. They're also in the news these days. We have a justice that's going to be retiring, and of course, we're going to see a nominee brought in front of Congress. It's different here in Ohio. Why are judges elected here in the Buckeye State as opposed to nominated?
Well, go ahead.
The reason judges are elected in Ohio actually goes back to 1851, which is when we have the Constitution that we have today was enacted. Before that, judges had been selected by the state legislature. And that actually caused a lot of controversy, because there was a sense that judges were too beholden to the state legislature, did whatever the legislature wanted. People said, we need to get away from that. So some people said, okay, let's go to the federal model. We'll have the executive branch, the governor, appoint judges. And people said, no, you have the same problem. They'll be beholden to the governor. So the idea that ultimately won the debate was that we ought to have judges that are truly independent. The only way to have judges who are truly independent is to have them selected not by another branch of government, but directly by you, the people. And so I think that's a pretty good idea, pretty good in theory. Sometimes one of the challenges is that people don't know as much about judges as they'd like to. You can't hold people accountable if you don't know anything about them. But that's why I think it's important that we do things like this and talk about what we do and what our philosophy is. And I appreciate the chance to be able to do that today.
You're campaigning for your position. So
Yes.
How is campaigning as a judge different from campaigning as another political office?
Well, first of all, you don't have all your First Amendment rights. Ethically, you wouldn't want us to either. You wouldn't want us to say, in this type of case, I will always rule this way, or in that type of case, I'll always rule that way, because then you're prejudging the case. You want people that'll sit back, listen, read the law, listen to the facts the jury found, and apply the law to those facts. You don't want somebody who's pre-conditioned. And so we have ethical rules that we have to follow to make sure that that happens. Things like we can't, well, this is more than 25 people. Normally, if I'm talking just to this gentleman, somebody one-on-one, I can't ask them for money, unlike your average politician. It's got to be at least 25 people. So if you want to give money to Fisher for Ohio, go ahead. But the point is these educational experiences like we're doing here are very important to understand the difference, what you're talking about, between they call the executive and legislative branches the political branches. And that's correct, because they got great First Amendment protection. We're not so much. We've got some limits. And that's a good thing, because you don't want a biased judge. Even if you lose a case, you want somebody who will listen. You want somebody who will care about the law and apply it to your facts. And thus, we kind of have to step back a little bit. And it does cause sometimes people come up to me all the time, why won't you guys do something about redistricting, or something like that. I can't talk to you about the case because it's pending. And it frustrates. But now, a lot of lawyers or people know what they're doing, like in this room. They won't do that to me. But people on the street, they oh, you're a justice, whatever, But I don't want to talk to them about the case because I don't want them to cause me to recuse. You want me on the case, I hope, to listen, to learn, and to rule. And thus, the rules are very different. Very different.
Justice DeWine, you mentioned you had agriculture in your background. You have politics in your family background as well. So is there anything you glean from others that have experience that you use in your campaign?
I've from a political standpoint, I've been fortunate to be around a lot of political campaigns in my life, and I think I picked up a few things about running campaigns, dealing with people, and I hope put those lessons to good use.
New on the ballot this year, next to their names, is going to be an R or a D. It's the first time in Ohio that we've seen that happen. How do you feel about that? And you mentioned just now about running for office being a little bit different and having to, walk a fine line, but now all of a sudden you're going to be categorized on that ballot. What's your opinion on that?
I think it's a good thing. I mean, my philosophy is that the more information voters have, the better. The reality is, whether you like it or not, the Ohio Constitution ordains that judges are going to run in partisan primaries. So unless you change the Constitution, we're going to run in a Republican or Democrat primary, at least in most cases. You can run as independent. Most people are going to be Republican or Democrat primary. And as long as you're going to do that, the question is, do we hide that fact from the voters, or do we tell voters that? And I think that we ought to err on the side of transparency and if someone's been endorsed by the Republican Party, put that on the ballot just like you would in any other office. Now, I'm not saying voters should vote based on that. They can do whatever they want with that. They can completely ignore it if they want. But I just think that as long as we have a system where judges do get endorsed by political parties, there's no reason not to be transparent with voters about that.
And I agree. I was president of the state bar, and they had two policies that to me were contradictory. I tried to get them to resolve it, and they didn't. One was they were opposed to an R&D behind the names, but they also wanted another major policy there, to get more people to vote for judges. And if you ever notice, the number of people that vote for judges is an undervote of like 20 to 30% compared to who vote for governor or president or senator. And we're going to see, finally, if I was correct, because I told him, I said, if you put an R&D behind their name, more people will vote. You might not like why they're voting, but more people will vote. And, that independence that Justice DeWine mentioned earlier about being an independent person, it always felt good to me that millions of people voted for me. Even if somebody in front of me didn't vote for me. it gives me the feeling I have the authority of you, the people, to make a decision. And I'm independent. I don't know anything to anybody but the voters of Ohio, all of them. And thus to have more people voting for judges, I think is a positive thing. I think having more people vote, because then maybe people pay attention to us a little more. I mean, a lot of people on election day call up their friend that is a lawyer or somebody involved in politics. Who do I vote for judge? Because they don't know, right? Well, it matters. In 2010, you mentioned my election. I think I won the election because I had a bunch of lawyers and friends on email and Facebook saying, vote for Pat Fisher, because it was a very close election. But if you go and tell people, hey, vote for whomever for judge, the odds are your friends, people you know from church, synagogue, whatever, they're going to vote for that person because they don't know, right? So it does matter, and judges do matter. If you haven't noticed lately, in the newspapers, a lot of cases are 4-3. Judges matter, and they matter every day, whether it's statewide like us or the local judge. Think what a local judge does. Local judge decides if Janie or Johnny is with mom or dad over the weekend, custody fight. Sometimes they have to take a little child away from a mother or father because they're a drug addict. During COVID, many cases, the judges had to decide whether grandma or grandpa got taken off the ventilator. We have to decide death penalty cases. Does a person live or die? These are very important matters, I think, whether a law is constitutional, whatever. And I think getting more people to care about who their judges are is a good thing. And thus, I think the R&D is a very positive thing for the long-term best interests of the state.
Well, I like to think, too, we have a couple hundred people in here that are gaining interest in this just because you guys are here visiting with us today, and they're going to see that ballot, recognize that name, and vote how they see fit. But now that there's more interest in this room, how would you recommend we, the people, researching judicial candidates and picking the ones that we choose? What is your advice as far as just finding out backgrounds and the way that you guys might think?
Well, at first I'd say you can read the opinions, but like the redistricting one was 146 pages. Not exactly, unless you really want to go to sleep at night, it could probably be helpful to you. But I think ask your friends that are lawyers, ask your friends who are involved, you can look up Ohio, or what's it, Judges Count?
Judicial votes count.
Judicial votes count gives some background information and can also lead you to our websites. Judicial votes count. And, you know, for years, the bar associations used to endorse or not endorse. They don't do that much anymore. But talk to lawyers. They will know. Your friends will know. And ask them. And I think, and associations like this, to be honest, will also help. Because while technically, you know more about what we think than any member of the political branch, because we have to put it in writing. It's very technical. Reading those things are not necessarily a fun thing to do every day. But I would ask people who would know, and they will tell you. And I think that's pretty good endorsement.
Justice DeWine, your advice?
Yeah, I think all those things, just as Fisher said. I mean, you know, and I think wherever you go between those places, I would think you would care most about the judicial philosophy of the judge. You know, you have to ask yourself, you know, do you want a judge who says they're a textualist, who says they're going to apply the law as it's written, or do you think judges should be more expansive in their powers and, you know, look at things like, okay, what should the law be? Do they believe in a living constitution? And I think it really depends. You know, you have to ask yourself those questions of, you know, what kind of judge do you want? Do you want a judge who's going to apply the laws as written, or do you want a judge who says, I think it's within our province to make the law? And then go read the judicial philosophies that you hear from any of those sources, judges, and see who fits your philosophy closest.
Justice Fisher, Justice DeWine, Leah Curtis. Let's give them a round of applause and show them our appreciation for being with us this afternoon. Thank you so much.
Thank you.